Chapter 3. Contract Law.
In a legal system such as ours, what makes a contract is sometimes misunderstood. Many people believe that a promise is only as good as your word, but that once it's written down, it then becomes a contract and the courts will enforce it, no matter how foolish or unfair it is. In this chapter, we're going to cover what a contract is, what forms a contract, what to do when a person is in breach of contract, and how a person might find themselves in a contract even if they didn't intend to make one. Elements of a contract. A contract is simply any legally enforceable agreement. Most people believe that a contract must be in writing, but that's not the case except in special circumstances, which we will discuss later. Even something like a handshake agreement is enforceable by the courts and not just relying upon your honor. If it includes all of the elements of a contract, offer, acceptance, and consideration, then the agreement will be enforceable by the court. Even though you don't have to put a contract in writing, it's still a good idea to do so, however. Even if the parties are trustworthy and have honorable intentions, there may be mistakes or misunderstandings that can be avoided by making all the terms clear in writing. The elements of a contract, offer, acceptance, and consideration, apply in most circumstances. However, there is something called the Uniform Commercial Code that also occasionally governs contract and other commercial law in the country. The Uniform Commercial Code, or UCC, itself is not law. However, the UCC has been ratified by all 50 states, so every state has statutes in place that substantially conform to the model UCC and to each other. The UCC primarily affects merchants and business people as opposed to laymen, and not every state includes every provision within the UCC, so you should take your time to review your own state's laws. Offer. The first thing required of a contract is that there is a valid offer being made. The contract will include the offeror and the offeree. The offeror is the person making the offer. The offeree is the person who has received the offer. For every offer to be valid, it needs three things on its own: intent, definiteness, and it must be legally communicated. Intent means that the offeror must have meant to make the offer to the intended offeree. This must be clear, and there must be no confusion that an offer is being made. The offeror can't be thinking about making an offer or simply putting ideas out into the ether. Definiteness means that the terms outlined in the offer must be clear. There must be no confusion about exactly what is being offered and what is expected to be given in exchange for the offer. If you go to the gas station and tell the clerk that you want to buy some gas for $20, then there's no valid offer. It must be clear exactly how much gas and for exactly how much money. The offer must be legally communicated from the offeror to the offeree. This is similar but not identical to the intent element. In short, the offeree must know that the offer has been made for it to be a valid offer. An offer can be legally communicated by email, a letter making the offer, a telephone call, or even verbally. The UCC makes some modifications to this requirement. Under the UCC, the only requirement is the intent element. Remember, the UCC primarily covers merchants. Consider how slowly commerce would be stalled if every time you wanted to go to the store, you had to find an employee and go through all the elements of a valid offer. You know that if you go to the grocery store and you find something on the shelves, that the grocer intends to sell you that item. Terminating an offer. If the offeror makes a valid offer, that offer can be terminated or voided by either the parties themselves or the government. The parties can terminate an offer in three circumstances. The first is if the offeror terminates the offer prior to acceptance by the offeree. Any time before the offer is accepted, the offeror can revoke that offer. However, once it's been accepted, you immediately have a valid contract if all three elements, offer, acceptance, and consideration, are present. The second situation is where the offeree rejects the offer. Once that offer has been rejected, it has been terminated. Full stop. That's it. If the offeree later has a change of heart and decides to accept that offer, the offeror is not required to accept it. What's happening in that situation is the offeree would be making a new offer with the terms flipped. Let's say that I offer to sell you a used car for $1,000. You reject the offer. In this case, I was the offeror and you were the offeree. Once you reject the offer, it is terminated. You cannot call me the next day and say you accept. If you call the next day saying that you do in fact want the car, you have become the offeror, making a new offer of $1,000 for my car. I can choose to either accept or reject that offer. The third situation where an offer is terminated is if the offeree makes a counteroffer. This is like the second scenario and really should be considered in the same light. If I offer you a car for $1,000 and you say that you'll give me $800 instead, then you have rejected my offer. I was the offeror and you were the offeree. The offer has been terminated. Your counteroffer has transformed you into the offeror, offering me $800 for my car. If I counteroffer, saying we should meet in the middle for $900, then I have rejected and therefore terminated your offer. I have gone first from offeror to offeree and now back to offeror again, as I have offered you my car for $900. If you accept it as the offeree, we have a contract. The UCC allows for a different type of offer, called a firm offer. A firm offer is one that cannot be revoked for up to 3 months. A firm offer is one where a merchant has made an offer in writing and mentioned in that writing how long the offer remains open. Firm offers are often seen in business flyers. Think about when you open your local newspaper and you see a flyer that says that the grocery store has a deal on steaks for $10 a pound for the next week. Oftentimes, this is in small print at the bottom of the flyer. If you walk into the store and buy a steak, they must honor that $10 a pound price until the date stated in the flyer. Acceptance. The next requirement for a valid contract is acceptance. Just like the offer, an acceptance also requires 3 things for it to be valid. It must be unconditional, unequivocal, and it too must be legally communicated. An acceptance must be clear. If the offeree adds an additional condition, then that person has made a counteroffer. An additional condition is a rejection of the offer, not an acceptance. If I offer to sell you my television for $500 and you say, I accept, but you need to toss in a Blu-ray player, then you haven't really accepted the television. You have rejected the television and made a new offer, the television and a Blu-ray player for $500. Now I have become the offeree, and if I want to accept, I must accept your terms completely. Clarity in an acceptance is met when it follows the mirror image rule. The mirror image rule simply means that the offeree is accepting the identical terms of the offer. It is like when you look at yourself in the mirror, what you are seeing is an exact copy of you, only flipped. If the offeror states, I will sell you my television for $500, then the offeree could technically accept by saying, I will give you $500 for your television. The terms are identical, but flipped. Any valid acceptance must be unequivocal. There should be no confusion about whether I'm accepting the offer. For example, if you offer me that television for $500 and I respond with, that sounds like a fair price, there could be some confusion over whether I'm accepting your offer, contemplating the offer, or simply stating that I think the price is good. So there is no acceptance. Just like how an offer must be legally communicated, so too must the acceptance be legally communicated. If I make you an offer and you decide you want to accept it, you just need to let me know. Just as with the offer, I can demonstrate acceptance by a handshake, an email, a letter, or handing you a check. Your acceptance needn't be in the exact same form as the offer. There are several different and unique ways a person can demonstrate their acceptance. I'm going to address just a few. With shrink wrap acceptance, a person demonstrates that they accept the offer by unwrapping or opening the package. Consider when you purchase loose leaf textbooks designed to be put into binders. When you unwrap that text and let the pages loose, you've demonstrated your intent to purchase the book and your acceptance of the price of the book. Like shrink wrap acceptance, simply accepting the goods may demonstrate acceptance. In our previous example, if I offer to sell you my television for $500 and send it to your door, we do not have any contract and you're under no obligation to pay. But if you take my television out of the box, plug it in, and watch it for a few weeks, you'd be very hard-pressed to argue that you haven't accepted my offer. It's been a valid offer made, so you know this television is not a gift. If you didn't want to accept the offer, you should have refused the television. Silence is another way to demonstrate acceptance, especially as it relates to services instead of goods. If I knock on your door and offer to mow your lawn for $30, then get started on the work, your silence will be counted as an acceptance. You could have stopped me before I started mowing. Because there was a valid offer, you knew I intended to mow and that I intended to charge you for it. So if I mow your lawn and ask for $30, you cannot simply play stupid and act like you didn't want me to do it. Under the mailbox rule, acceptance counts at the exact moment it has been legally communicated. If I were to call and offer to sell you my television for $500, and you were to email me to tell me that you accept, the minute you press send, the contract is formed so long as there is a valid offer, acceptance, and consideration. If I have already sold that television to another person before checking my email, then I will be in breach of contract since I can no longer honor my obligation of giving you the television that you accepted. A good way to avoid getting into a situation like this would be to specifically state how acceptance must be communicated as part of your offer. Another common alternate form of acceptance is available under the UCC. Under what is known as the Battle of the Forms, merchants governed by the UCC sometimes send offer letters, which are met with acceptance letters, instead of having just one document signed by both parties. Under this doctrine, a contract may still be formed even if the mirror image rule is not met. This has the potential for a great deal of conflict over the terms of the contract, which must often be resolved by the courts. Remember, the Battle of the Forms only applies to merchants under the UCC. Consideration. The final element of a contract is consideration. Consideration is simply something of legal value. Consideration is not only money. Consideration is anything you can attach a legal value to. Money is consideration. Goods are consideration. Services are consideration. What counts as consideration could even change depending on the legality of the jurisdiction. Marijuana is legal in many states. It would qualify as consideration, but only in those states. Prostitution is legal in many areas of Nevada. In those areas, even sex could qualify as consideration, but would not be legal consideration anywhere else. For consideration to be valid, it must conform to the doctrine of mutuality. Under this doctrine, both parties gain consideration and both parties give consideration. If I offer to mow your lawn for $30 and accept, there is valid consideration. I am getting $30. You are getting a freshly mowed lawn. I am losing my time and labor. You are losing $30. If I buy a television from Walmart for $500, consideration changes hands. I am getting a television. Walmart is getting $500. I am losing $500. Walmart is losing a television. The consideration both parties exchange must be clear. Both parties need to know exactly what they're getting. An illusory promise is not valid consideration. An illusory promise would be consideration that is not clear and definite. If the local restaurant offers you all the ice cream you need for $5, this could be considered an illusory promise. How much ice cream do you need? The restaurant could argue that you don't need ice cream and therefore not to give you a single scoop while stating that they're still doing what they agreed to do. Types and status of contracts. We've discussed the elements of contract. All contracts need an offer, acceptance, and consideration to be considered a valid, enforceable contract. Next, we're going to talk about several different types of contracts and what makes them unique. Contracts may fall under multiple categories. Then we'll talk about the status of the contract. In addition to the following types of contracts, all contracts will also be one of the 3 V's: valid, void, or voidable. Our first type of contract is an express contract. This is first because it's the simplest and most common of our types of contracts. The terms of the contract have been clearly expressed. And if we were to continue in a business relationship, the terms will be clearly expressed and repeated every single time we do business. If I come to your house, knock on your door, and offer to mow your lawn for $30, then the terms are clear. A mowed lawn and $30. We know who the offeror is, me. We know who the offeree is, you. There's offer, acceptance, and consideration. This is an express contract. Implied contracts. With an implied contract, one or more of the terms are still clear, but they haven't necessarily been openly expressed prior to entering the contract. We see this most often when we're talking about a recurring situation. With an implied contract, silence can be considered a form of acceptance. Let's say that I offer to sell you a dozen eggs from my chickens for $3. We have an express contract. I come by the next week and make the same offer. You accept. We again have an express contract. We repeat this process for several weeks. I come by 1 week and you're not home and your son answers the door. I give your son a dozen eggs and leave. The following week I show up with another dozen eggs, but this time I demand $6. $3 for this week's eggs and $3 for last week's eggs. You would still be required to pay for the previous week's eggs that you received, even though you weren't home to accept the eggs or to expressly accept my offer to sell them to you the way that we had done it before. What we have in this case is an implied contract. It is implied that you accept the offer of a dozen eggs for $3 because you've accepted them many times already. Neither of us can change the terms of the contract, however. We can only operate by the terms we have used frequently in the past for an implied contract. Implied contracts can sometimes have a murky reasonableness factor. Let's say our implied contract is for shoveling your driveway. I've been shoveling your driveway for several weeks. I come by at my regular time, but it looks as though you shoveled that morning. Your driveway is clear. I cannot simply push my shovel over your clean driveway and expect you to pay me. It's unreasonable for me to believe that you'd want me to shovel your driveway in that case, so I would not be able to claim that there was an implied contract. Bilateral and unilateral contracts. Bilateral contracts also fall into the most common contractual scenarios. With a bilateral contract, there's a clear offeror and offeree. If you go to the mechanic and he offers to change your oil for $80, we know who the parties are. The offeror is the mechanic who will change your oil. The offeree is you who will receive the oil change. Both parties have entered into an agreement and are bound to honor those terms. With a unilateral contract, only one person has entered into a binding agreement. In most cases, there's a clear offeror who has cast her offer out into the world. The offeree demonstrates their acceptance by doing what the offeror has asked. Let's say I need my grass cut. I put out a sign in my front yard saying that I'll pay $30 for whoever mows my lawn. I don't care who mows my lawn. I just want the work done. I'm not asking anyone in particular to do the work. There's no clear offeree. Whoever shows up and mows my lawn demonstrates their acceptance by doing what was asked. This unilateral contract is only binding on me, the offeror. No one is obligated to mow my lawn, but I am obligated to pay whoever does the mowing. Unilateral contracts can sometimes run into unexpected conflicts. Recall that an offeror can terminate an offer at any time until it has been accepted. An offeror in a unilateral contract cannot terminate their offer once a reasonable person would believe that the work has begun and is likely to be completed. If you arrive at my house with a lawnmower and have not yet started to mow, I can still revoke the offer. But I cannot wait until you're almost done and then run out and revoke the offer when you've only got a strip of grass left to go. When you cross the point of acceptance, it depends on what the terms of the contract are, and they may change depending on many variables. Option contracts. The last type of contract we're going to discuss is the option contract. An option contract is similar, but not identical to the firm offer we spoke about earlier. Recall that a firm offer is not a contract, but an offer made by a merchant under the rules of the UCC. With an option contract, we have a completed contract with offer, acceptance, and consideration. The consideration in this case is the exclusive rights to another non-revocable offer for a separate contract. Let us say that I'm offering to sell my current hard-to-find PS5 for $300 over market value. You really want it, but you heard that there's going to be some new ones hitting the store shelves this weekend. You don't want to lose out on the chance to buy mine, but you don't want to buy mine and find out you could have gotten a new one for cheap this weekend. So we enter into an option contract to buy my PS5. You offer me $20 to not change the price or sell it to anyone for the next 5 days. There's an offer. I accept your offer. And there's consideration. I am getting $20. I'm losing the chance to sell it to anyone else for the next 5 days. You are gaining the exclusive opportunity to buy it if you want for 5 days. You're losing $20. Now remember, contracts can fall under multiple categories. In this case, our contract would be an express bilateral option contract. Status of contracts. All contracts will either be valid, void, or voidable. A valid contract is simply a good, legal, enforceable contract with no defects. However, there are times when a valid contract is still unenforceable by the court. We'll discuss those soon. A void contract is one that is unenforceable by the court. This is due to some defect in the contract itself or the process of making it, such as lack of consideration or illegality of the subject matter. The final type is a voidable contract. A voidable contract is one that is able to be voided by one of the parties if they wish. If that person still desires the bargained for consideration in the contract, they must uphold their part of the bargain. However, if they decide that they would like out of the contract, then they can choose to void the contract and not go through with it. Capacity. Both the offeror and the offeree involved in a contract must be of sound mind for a contract to be valid. If one party to the contract lacks capacity, the contract becomes voidable. The person who lacks capacity is not bound to the agreement unless they want what was agreed upon. The person who had capacity cannot ever choose to opt out of the contract. What sorts of things cause a person to lack capacity? Mental health problems are one of the more common areas where a person is lacking capacity. You cannot use the fact that a person has a mental illness or is otherwise incapacitated to take advantage of them. A person under the age of majority lacks capacity. A person who's under the influence of alcohol or other drugs may also be considered lacking in capacity in some circumstances. A person suffering from an injury like a concussion, causing them to not be fully aware of what's going on, also brings their capacity into question. Drugs and alcohol are a somewhat more difficult area. You cannot actively take advantage of a person who is under the influence of mind-altering substances. However, if a person has willingly and knowingly put themselves into a position where they lack capacity, they will be held for contracts that they enter into. In other words, you cannot simply fall back on the fact that you were drunk to get out of your foolish decisions. Once a person gains capacity, such as when they meet the age of majority in their jurisdiction, or when they sober up from medication, they must either ratify or disaffirm the contract within a reasonable period. They cannot just leave the contract in a position of limbo forever. If they ratify the contract, it becomes valid. If they disaffirm the contract, it becomes a void contract. If they choose to disaffirm the contract, they may still be held liable for necessaries. These are things that cannot be returned and are necessary for ordinary living. Things like food, water, shelter, soap, and similar consumables would qualify as necessaries. You cannot simply eat a bunch of food and then disaffirm the contract after you've done. A disaffirmed contract in this case will still normally require you to pay a reasonable, albeit lesser, price for those goods. Most of the time, that amount is the amount it cost the person who sold it. Legality. If the consideration being bargained for is illegal, the contract is void. If a person enters a murder-for-hire contract with a hitman and the hitman doesn't do his part, the court is not going to order the hitman to get to work. Impossibility. Sometimes you have a valid contract, but external circumstances occur which make it impossible for the party to uphold their end of the contract. Under the doctrine of impossibility, the courts are not going to hold a party responsible for a good faith breach of contract when it becomes impossible to do what they contracted to do. If I enter into a contract with a lumber company permitting them to cut some trees on my property, and a forest fire cuts through my property burning the trees down, the lumber company cannot hold me responsible for not providing them the trees. However, I must have taken reasonable care in order to be protected by this doctrine. If I were to cause a fire myself through my own negligence and the trees burned down, then I could still be held responsible. The public policy exception. Sometimes there's nothing specifically wrong with the contract, but the courts will refuse to enforce them as a matter of public policy. If the court determines that it would be bad for society that the contract be enforced, sometimes the court will make that determination as a matter of public policy. There are some situations where the court will frequently enact the public policy exception. If the court determines that the contract is overly litigious, the courts frequently refuse to enforce the terms. An overly litigious contract is one where the main intent of the contract is not to actually conduct business, but rather for one party to catch the other in breach of contract so they can bring them to court and profit from the lawsuit. The purpose of the court system is to resolve conflicts, not to enable them. In some circumstances, non-competition agreements may not be enforced. The courts will make a subjective determination as to whether limiting the type of goods or services in the area will be damaging to the public. Doctors, lawyers, and other vital and expensive services are frequently cited examples of non-competition agreements not being enforced by the courts. A local fast food restaurant's non-competition agreement is likely to be upheld by the court, but a non-competition agreement by the only grocery store in town is unlikely to be enforced. In matters of unconscionability, the courts will also refuse to enforce contractual terms. Contracts unenforced for unconscionability frequently are so unfair that no reasonable person would accept it. Often, this means that the contract was written in a confusing way to take advantage of a less knowledgeable party. Frequently, this also involves adhesive contracts with major imbalances of power. An adhesive contract is one where the contract is not negotiated, but established by one party that tells the other to either take it or leave it. Adhesive contracts are quite common and often upheld by the courts. It is when there is a major imbalance of power when the courts begin to scrutinize whether to enforce it. If a person is dying of dehydration and you offer them a bottle of water for $1,000, they're likely to accept despite how unfair the terms are. They're desperate for that simple bottle of water, and their life is on the line, so they'll pay anything. Contracts such as this are rarely upheld by the courts under public policy exceptions. Fraud. When a person induces another to enter into a contract by lying or trickery, courts will frequently find that contract to be voidable. A person induced into a contract by fraud not only is able to get out of the contract, but is often able to get punitive damages on top of the actual damages that they've suffered. Fraud is not a simple mistake, though. It requires several elements to be present. The first element is a knowing mistake of material fact. In other words, the bad actor isn't just wrong, but they know they're wrong. They know they're lying, and that they're lying about something relevant to the deal. A material fact is a fact that is something that is important to the bargain. If you purchase a product, and when it arrives in the mail, the package is a different color than on the website you bought it from, that is not a material fact. No one cares what the box looks like. All that is relevant is what's in the box. Additionally, puffery is not fraud. Puffery is an exaggeration that a reasonable person would know is not to be taken literally. When you go to a restaurant and buy the world's greatest burger, you expect a tasty burger, but not literally the greatest burger in the world. The second element is an intent to deceive. The seller must not only know that what they said is false, but that they did it to induce you into the contract. The third element is that the buyer reasonably relied on that false statement. If the buyer knows that the seller is lying and enters into the contract anyways, they cannot claim that there was fraud. Both parties knew what was being contracted for. The buyer's reliance on the seller's statement must be reasonable. If the buyer was being foolish, and any reasonable person would have known that they were being lied to, they cannot sue for fraud. Finally, the buyer must have suffered some damage. If, by some turn of fate, the buyer actually profits, then they have nothing to sue over since they weren't harmed. The point of the courts is to help those who have been harmed. Duress. A person under duress cannot consent either to making or accepting any offer. This makes the contract voidable. The person who is under duress has the option to void the contract. When we think of duress, most of the time our first thought is that someone is using violence. If a person were to tell you to sell them something or they'll beat you up, then you'd not be making that offer freely. You'd be making the offer to avoid getting beaten up, not to turn a profit. But duress doesn't always have to be violence. If your boss threatens to fire you unless you contract with him for something, then you're also under duress. You're making or accepting an offer with the intent that you not be fired, not for the actual consideration in the contract. Undue influence. Undue influence isn't duress, but there is an implication that the person making or accepting the offer isn't really doing it freely. With undue influence, one person is exerting the power over another person to get them to make or accept an offer they otherwise wouldn't. This could be nearly anyone in a position of authority, and often involves a relationship with an imbalance of power. A common example of this is where an elderly person is left under the care of a live-in nurse. When the person dies, it's uncovered that the caregiver has been left a large amount of property in the elderly person's will. In this instance, it will be the estate or the surviving heirs alleging that the caregiver exerted the position of power to convince, cajole, or implicitly threaten the withdrawal of care to get themselves written into the will. Mistake. Mistake is a more complicated matter where one or both of the parties have made some mistake of material fact that changes the terms of the contract from what was expected to have been bargained for. Remember, the mistake must be material. As discussed before, a material fact is one that is important and relevant to the bargain. Not just any mistake will affect the deal. Most mistakes are unilateral, that is, made by only one person. In this case, most of the time the contract remains valid, and the person that made the mistake is simply left with the bad deal. So far as the court is concerned, the person that made the mistake should have been more cautious in the bargaining process. However, if the mistake is one that a reasonable person might make, and the other party knew or should have known about it, they cannot take advantage of the mistake. The contract is then voidable by the person making the mistake. The court does at times also intervene as a matter of public policy for unconscionability if the mistake is severe enough. Some mistakes will be made by both parties. With mutual mistake, both parties are in error about the terms of the contract. In this case, the contract will become voidable by either party. The statute of frauds. Not all contracts must be in writing. As mentioned at the beginning of this chapter, If the elements of contract, offer, acceptance, and consideration are present, then the contract is valid regardless of whether there's a written instrument or even a handshake. However, under the statute of frauds, there are a few circumstances where contracts are required to be put in writing. Your state laws may vary about everything that falls under the statute of frauds. There are more, but a few common examples are prenuptial agreements, contracts that cannot be performed in under a year, contracts involving real property, so land or interest in land, and goods over $500. The reason contracts such as these are required to be put in writing is found right in the name. These are the sorts of situations where a high likelihood for fraud or mistake exists. Note that with contracts that cannot be performed in a year, that this is meant in only the most extreme and literal sense. In even absurd situations where there is no reasonable possibility of completing the contract within a year, the statute of frauds will not apply unless it is literally impossible for the contract to be fulfilled. For example, if I promise to build you a bicycle from scratch and ride it across the globe, you do not need a written contract. But if you promise to care for my dogs for the next 2 years while I do it, it does need to be in writing, since a superhuman can accomplish the former, but it's impossible by definition to watch dogs for 2 years in under 1 year. In cases where the parties do not put something in writing that is required under the statute of frauds, the court might still enforce it in part or in full depending on other factors, such as if the parties have already begun what they'd agreed to. This can become extremely messy for the courts to deal with. The parole evidence rule. If a contract is placed in writing, the parole evidence rule prevents any external agreements from being introduced to modify or alter the contract. This is true even if the contract was not required to be put into writing by the statute of frauds. If you buy a used car and the dealer orally promises to do maintenance on it for the next year, but that promise is not included in the written contract, then the courts will not enforce it as part of the contract if the dealer fails to do what was promised. There are several exceptions to this rule, and you need to review state law. But in general, the parole evidence rule will limit your contract to only what was agreed upon in the writing. Most exceptions to this rule are designed to show fraud, duress, mistake, or some other defect in the formation of the contract, as opposed to including or removing things that were not included in the original written contract. Contract remedies. When a person sues for breach of contract, there are several things they can request in the prayer for relief found in their complaint. We'll talk about the types of damages and remedies a person might request when they say there is a breach of contract by the other party or some other type of defect. Keep in mind that if a person is suing for damages, they have a duty to mitigate those damages. The duty to mitigate means that the injured person must attempt to limit the damage that they're suffering. They cannot simply allow damages to accrue that could have been avoided. If someone fails to attempt to mitigate damages, the courts may opt to only provide partial relief for the unavoidable damages. The following are some types of remedies a person may be granted in court. Note that not all damages a person requests must be for money. Compensatory damages. Compensatory damages are the most common type of damages sought when there is a breach of contract. With compensatory damages, the injured party is seeking to be put in the same position they would have been in if both parties had gone through with what was promised in the contract. With compensatory damages, a person is not seeking to achieve any greater profit than if everyone had simply done what was expected. Imagine a situation where I promised to sell you a rare book for $300. There is a good, valid contract with all the necessary elements. Later, before the book is delivered, I find out that I had accidentally sold it to someone else before I made you the offer. I am in breach of contract with you, and you sue for compensatory damages. The next cheapest copy of the book is $500, and you buy it. In this case, you'd be able to recover $500 in compensatory damages if you'd already paid, or only $200 had you not already paid. Compensatory damages are simply the amount of money you actually paid minus the amount of money that you agreed to in the contract. Therefore, you are not receiving anything for free. You're getting exactly what you'd bargained for. If you had to spend $500 on the book, but agreed in the contract on $300, then you had to pay an extra $200, and that's what you're entitled to recover. So the result is that you still get the book by spending $300. Consequential damages. Next, we have consequential damages. Consequential damages are those damages that naturally flow out from and are reasonably expected because of the breach of contract. One way of looking at it would be as a lost opportunity cost. In the previous scenario, Imagine that you were a fight promoter that had booked an arena at $30,000 for a major title fight that weekend. The arena seats 20,000 people, and you plan to sell tickets at an average of $80 per ticket. The arena owners breach the contract and do not give you access to the arena. As I mentioned earlier, you have a duty to mitigate, so you try as hard as you can to find a new arena. This arena requires a lot of extra work to set up, costing you $50,000, and it only seats 15,000 people. So the first thing you'd ask for in your lawsuit is compensatory damages, the $50,000 you actually spent minus the $30,000 you agreed to spend. You would then sue for consequential damages, the natural damages you suffered from the breach. Initially, you were going to sell 20,000 tickets, but now you're only selling 15,000. If the ticket price remains the same, your consequential damages are 5,000 seats at $80 per seat, or $400,000. Liquidated damages. Liquidated damages are those damages you physically write into the contract that the other party agrees to pay in the event they breach. You might put in your contract that a breach will cost you the money you're required to pay the fighters and the other employees in addition to the lost ticket and television revenue. The arena owner might address the damages they'd suffer by not getting to allow someone else to purchase the use of the arena in the event you don't have to fight and are unable to pay. Putting liquidated damages in the contract is a good idea because it simplifies some of the potential struggle that comes with having to prove in court what your compensatory and consequential damages are. In the previous example of lost ticket revenue, you'd be able to prove to a jury that you'd have been able to sell out that 20,000 seat arena. The arena's attorney will likely try to prove that even if you were at capacity at 15,000 people, you'd never have been able to fill out the larger arena, which would lower the amount of consequential damages you could recover. Punitive damages. With both compensatory and consequential damages, you're only recovering the actual damage you suffered due to the breach of contract. The point of suing for breach of contract is to ensure the plaintiff enjoys the benefit of the profit he'd have made had the parties simply done what they'd agreed to. It is not to make some more money than they otherwise would have had. However, there are some circumstances where you can receive more money. With punitive damages, the court is punishing the losing party for their bad behavior. Punitive damages are not common and often are awarded only when there is extra egregious behavior, such as when someone uses fraud, duress, or takes advantage of someone's lack of capacity to enter into unfair contracts. Nominal damages. Sometimes there's a clear breach of contract, but the plaintiff is unable to prove any substantial damages. With nominal damages, the plaintiff is awarded a very small sum, such as a single dollar. Nominal damages aren't real damages, but rather damages in name only. The main value in nominal damages is that for punitive damages to attach or attorney's fees to be awarded, there must be a winner of the case. If a person receives $1 in nominal damages, then they're the official winner and the court may award those additional monies. Rescission. With rescission, instead of only ordering money damages, the court will simply undo the contract. This may happen with or without the previously mentioned damages being applied. With rescission, the court is canceling out or undoing the contract. In most circumstances, you will see this when the consideration bargained for the contract has not yet changed hands and there is some sort of defect in the contract. Rescission is a common remedy when a person is in an avoidable contract and disaffirms it before either side has suffered any real damage. Specific performance. Not all breaches of contract can be solved with money. If the consideration involved in a contract doesn't consist of money or some sort of goods, the court may order people simply to do what they promised. This is called specific performance. Imagine that a person purchases access to their neighbor's land for an easement. The other person installs a gate or otherwise denies the person who purchased the easement access to the land. The court may simply order that the gate be torn down, or the person who purchased the easement be given the key or access codes. A failure of the defendant to do what the court ordered may result in fines or, in extreme cases, jail time, as they would be in contempt of court for violating the judge's order. Reformation. The final common remedy utilized by the court is reformation. With reformation, the court is literally reforming or modifying the contract. Sometimes the parties still wish to continue to do business, but are simply disagreeing on what the terms of the contract are. Perhaps there's been a mutual mistake by the parties on what the contract was supposed to say or what it meant. Perhaps the terms fall under the doctrine of unconscionability, such as one with usurious interest rates. In cases such as this, the court will keep the contract in place but modify the terms. Alternative forms of contract. Sometimes there are defects in a contract, but the court enforces terms anyways. This is referred to as quasi-contract, constructive contract, or implied contract. Parties might exchange consideration in full or part when the elements of contract aren't clearly present. In some cases, the consideration is something that must be in writing under the statute of frauds, but the parties didn't put the agreement in writing. In the following scenarios, parties may be held to quasi-contract. Promissory estoppel. If a person has reasonably relied on statements made by the other party and suffered some loss for it, sometimes the court may form a contract despite there being no clearly communicated offer or acceptance. Your friend tells you that they really need to borrow your pickup truck to move this weekend. You have a pickup truck, and you're also an Uber driver. You, reasonably assuming that your friend was asking to rent your pickup, do not go out on your Uber runs that weekend. Your friend hires a moving company to help him move instead. In this case, you might be entitled to the cost of renting your pickup. However, this contract could only be inferred by the court if they agree your reliance upon their statement was reasonable. If your statement was unreasonable, or you suffered no actual loss, then the court will deny your quasi-contract claim. Unjust enrichment. The primary goal of quasi-contract is to prevent unjust enrichment. Under unjust enrichment, 3 elements must be present. The defendant must gain consideration, the plaintiff must lose consideration, and it must be unfair for the plaintiff to not be compensated. The primary difference between other forms of quasi-contract and unjust enrichment is the amount the plaintiff can recover. With unjust enrichment, the plaintiff is only able to recover the amount that he spent, as opposed to the potentially much higher recovery under other forms of quasi-contract. In other words, the plaintiff is not going to turn a profit like he would have with a valid bargain for contract, but we want to ensure that the defendant isn't getting any consideration for free. Your car runs out of gas in the middle of the desert. A pickup comes by and puts 5 gallons of gas in your car, enough to get you to the next gas station. If you accept the gas, even in the absence of a clear offer, the gas owner can require you to pay him for the gas if you've accepted it. Now, if the owner of the gas asks for an exorbitant amount of money for the gas afterwards, say $20 a gallon, then he might not be able to recover that much under quasi-contract due to the serious imbalance of power between you. If you were within walking distance of a gas station, there would be no imbalance of power. But given that you're in the middle of the desert, miles away from help, you're desperate for that gas. However, under unjust enrichment, he'd be able to recover $5.50 per gallon, the current cost of gas. He doesn't turn a profit, but he doesn't lose anything either. Warranties. Goods purchased by merchants are covered by warranties under the UCC, whether one is outlined in the contract or not. Warranties can either be express or implied. An express warranty is the warranty that is clearly written out and outlines all the terms of that warranty. It could come with the purchase, or you can purchase it separately. Under an implied warranty, a new product purchased from a merchant is warranted to do exactly what it is advertised to do. If you buy a toaster from Walmart and it doesn't work, you can take it back regardless of whether you bought a warranty to go with it. An implied warranty will only last for a reasonable amount of time. If you buy the toaster and it doesn't work 5 years later, you cannot take it back and expect them to accept it. Remember, though, that this is under the UCC, so it only applies to merchants, not something you purchased at a garage sale. Contract interpretation. One of the biggest problems that courts face is one of the biggest reasons people use courts in the first place. A great many lawsuits for breach of contract revolve around disagreements over what the terms of the contract actually mean. What seems completely obvious to one person might be different, but completely obvious to the other party. A good example of this is the case Fergalment versus B&S, where the parties disagreed over exactly what a chicken was. Fergalment Importing Company versus B&S Intern Sales Corp., 190 Federal Supplement 116. Confusion over terms is especially likely in those instances where an oral contract is being argued over. That is why, even with two parties who intend to deal honestly with each other, you should still get a contract in writing. This also happens frequently with boilerplate contracts, such as generic ones you buy online or through office supply stores. We'll cover a few factors that a court considers when interpreting ambiguous terms. However, as a last resort, if they do not work, the court will interpret ambiguous terms against the drafter. It is expected that the person who drafted the contract will be in the greater position of power in the business relationship, and that puts the duty to write a clear contract on them. The Four Corners Rule. When determining what the terms of a written contract mean, the court will employ the Four Corners Rule. Under the Four Corners Rule, the court will only consider the actual text itself. No information outside of the four corners of the written contract will be considered to define ambiguous terms. This is much like the parole evidence rule. The only difference is that the parole evidence rule disallows adding new terms. The Four Corners Rule disallows looking outside the document to define the terms already within it. Specific terms versus general terms. The court will seek to use the definitions provided within the contract to define the ambiguous terms before considering their plain or dictionary meaning. Many good contracts will include a section specifically defining any possibly ambiguous terms. This is really nothing more than an extension of the Four Corners Rule. If you define your terms within the contract, the court will use the definition provided within the four corners before looking outside to seek any plain meaning from the dictionary. Ordinary meaning versus technical meaning. If the court cannot find any help in defining the ambiguous terms within the four corners of the contract, they will consider the ordinary or plain meaning of that word before any technical meaning. In other words, if one party is arguing that the word means something correct but obscure, the court will instead apply the more obvious and normal meaning to the word. Course of dealing. The courts will always consider the course of dealing between the parties. This is more likely to come into play when you're talking about a business relationship that has been active for longer periods of time. If the parties have been behaving as though the terms of the contract mean one thing, the court is not going to suddenly accept it when suddenly one of the parties argues that the terms in fact mean something else. This is important to consider in your business relationships. In the same way that accepting goods may qualify as accepting an offer and forming a contract, accepting the terms of a contract instead of immediately addressing the problem signals to the court that you understood and agreed to the definition of the ambiguous term. Common business usage. Lastly, we will consider common business usage. Some words have specific and unique meanings within an industry. In law, the word treble means triple, whereas if you're talking about music, treble means high-pitched. The court will consider the possibility that even if a word has a plain or obvious meaning, that it might well have a different meaning in your contract due to the unique nature of your industry. The best way to avoid arguments in court is to define your terms within the contract.